The 14th Amendment proclaims that no state shall deprive any person of life, liberty, or property without due process of law. The Fifth Amendment contains identical language that guarantees that the federal government is also required to adhere to the standard. The most basic purpose of the Due Process Clause is to guarantee that you get a fair hearing before the government can deprive you of life, liberty, or property. As you can imagine, there's a great deal of variance between the forms of due process and the level of due process depending on what the issues are. If you're charged with capital murder, for example, the processes are elaborate, complicated, and very much for the protection of the person charged with such a crime. If the government is trying to take some small chunk of your property, the processes are a little different. But that doesn't mean that you can do entirely away with due process for the smallest of things, like a parking ticket. In fact, parking tickets are near and dear to my heart because my first big constitutional victory was about parking tickets. I was a law student at the time in the city of Spokane, Washington, and I was working downtown as a legal intern and trying to save some money by parking on the street and putting coins in the meter as often as I could. And I ended up with 10 parking tickets. As I was thinking about defending myself, I had to ask, how are they going to prove that I'm guilty of this? Because it was a crime to do overtime parking. It was a misdemeanor under the Spokane Ordinance. Well, I went to the law library and discovered that Spokane's law presumed that the owner of the vehicle was guilty of a misdemeanor. This just didn't seem right to me. And in the law library, I researched and concluded that this presumption of the guilt of the registered owner violated the constitutional rule on the presumption of innocence. So I wrote a brief with my constitutional arguments and went to traffic court to fight my 10 tickets. I'm not kidding you when I tell you that the name of the judge was Judge Gump, Ellsworth Gump. I handed him my brief and began arguing the constitutionality of Spokane's parking ordinance. And he stopped me just as I got going and said, "Mr. Law Student, let me ask Mr. Prosecutor a question. Mr. Prosecutor, what's the maximum penalty I can impose on Mr. Law Student if he continues to argue this case?" And the prosecutor said, "There's a $1,000 fine and 30 days in jail for each of these 10 tickets." Judge Gump said, "Mr. Law Student, if you want to keep arguing the constitutionality of this law, you just go right ahead. But at the end of the case, I'm going to impose the maximum penalty on each of these 10 tickets. Or if you want, you can go out in the hallway with Mr. Prosecutor and make a deal with him for $10 a ticket." Well, I did a quick calculation. That would be $10,000 and 300 days in jail, and I didn't want to take the chance. By the way, the president of the local bar association was in the courtroom and watched all this and later told me that what the judge did was highly unethical. But that was what happened at the time, and I caved in. But 2 years later, a paying client walked into my office, and now I'm a lawyer. He wanted to fight parking tickets, and he had this crazy theory about the right to travel or something else, and I told him that theory won't work, but I know what will: the presumption of innocence. So we filed my brief again, and we ended up this time in front of Judge Thompson. Judge Thompson listened carefully and ruled at the end of the case that the Spokane Ordinance violated the 14th Amendment Due Process Clause because it didn't follow the presumption of innocence. All parking tickets in Spokane were illegal, but the city appealed. We ended up in the Superior Court of Spokane County. Judge Harold Clark agreed with Judge Thompson, ruled that the statute was unconstitutional. The city appealed again. We ended up in front of the Court of Appeals that again ruled that the Due Process Clause required the presumption of innocence in every crime, including the crime of overtime parking. At the time in Spokane, apparently, there were $3 million worth of parking tickets on the books. All of them were ruled unconstitutional and void by the decision that I was able to win in that particular case. The city had to change its law, shifting away from a crime for overtime parking into a civil ordinance. And now they could presume that the registered owner was responsible, but that's different than presuming he's guilty of a crime. They could only fine him, but they couldn't threaten him with arrest warrants or jail time or otherwise threaten his constitutional liberties over a parking ticket. This story has several lessons about due process, but the last one is to highlight the fact that there's a big difference between due process requirements in criminal cases as compared to civil cases. But you're always entitled to some form of due process, from the most important case down to the lowly case of a parking ticket. In the case of Cleveland Board of Education versus Loudermilk, the Supreme Court gave us a very important statement about due process. An essential principle of due process is that a deprivation of life, liberty, or property be preceded by notice and opportunity for hearing appropriate to the nature of the case. The rules of due process are invoked only when the government is going to deprive you of your life, your liberty, or your property. We're going to focus solely on the issues of deprivation of liberty and property, because if the government's trying to deprive you of your life, that's a capital offense, and you need better legal advice than you can get on a video series. So we'll focus just on liberty and property. You're not entitled to due process every time the government makes a decision that affects you and you don't like it. For example, let's say that you're camping in Yellowstone Park. And under the normal rules of the park, you're entitled to stay in the camping spot you selected for up to 7 days. But only after being in the park for 2 days, the rangers come to tell you have to move because the president is taking his family camping and he's going to be very close. They have to close this part of the campground for security purposes. Well, in that circumstance, the government doesn't have to give you a hearing before taking away your campsite. You don't have a property interest in the campsite. You may have some kind of a moral claim, but you don't have the kind of claim that rises to the level of a protectable property interest that requires a hearing before it can be taken from you. Obviously, if the government is going to take your land or your car, due process is required because those things are your property. But property rights have been recognized in a great number of cases involving benefits that people receive from the government. For example, in the case of Board of Regents versus Roth, the Supreme Court held that a government employee who had a legitimate claim to continued employment could not be fired without first giving her a hearing to determine if there were sufficient grounds to discharge her. This is not a rule that applies to the private sector in general, but only in government employment. Additionally, in Morrissey versus Brewer, a person on welfare was held to have the right to a due process hearing before they could be terminated from receiving benefits. The hearing was to determine whether or not the person was still eligible to receive the benefits. Students in the public schools cannot be expelled for 10 days or more without a due process hearing to determine whether or not they committed the acts that justify their removal from school. It's easy to conclude that the Supreme Court was right in ruling that some form of due process was required before you could expel students from the public schools for 10 days. But when they get into the details, you realize that what the Supreme Court is doing here, as it's done so often, is they're just making the rules up out of thin air. They're common sense rules. There's the kind of rules that you'd want the school board to make or the state legislature to make, but it's kind of troublesome when the Supreme Court is making the rules. They said if the suspension is more than 10 days, then you've got to have a full hearing. If it's less than 10 days, all you need to do is tell the student what they're charged with, give them some idea of the evidence against them, and give them a chance to explain. It can be done all very informally. Common sense rules, good rules, but the question is, should the Supreme Court be allowed to make up those rules out of thin air? It's my contention that the Due Process Clause is not grounds for the Supreme Court to write legislation. They should be able to rule whether or not a particular rule in question was good or bad, but they shouldn't force the school districts to follow the details of their policy that they're just writing like a legislature. Government jobs, welfare, public school attendance, these are all classified as property rights, although they are very different from the kind of rights that the founders thought they were protecting when they wrote the Constitution. But the basic rule followed by the court is this: even though the state legislatures are not required to give people jobs, welfare, or public school attendance, once they do, they have to adopt a fair process before they can take any of these things away. Once it's determined that a person is entitled to some form of due process, there's a second question that's almost always phrased like this: what process is due? In the Loudermilk case, the Supreme Court said that the general answer to this question is that any deprivation must be preceded by notice and an opportunity for hearing appropriate to the case. All that was required in Loudermilk before the school janitor could be fired was oral or written notice of the charges against him an explanation of the employer's evidence, and an opportunity to present his side of the story. There are a number of Supreme Court cases and literally hundreds of lower court cases that have fleshed out the details of what kind of process is due in a wide variety of circumstances. But I want us to focus a little bit on the rights of criminal defendants, particularly the rights of criminal defendants in the area of where they're being interrogated by the police. I want us to watch some famous crime dramas to get an example of what the Supreme Court has done. See if you can pick out the Supreme Court's influence in these two episodes.
Ladies and gentlemen, the story you are about to see is true. The names have been changed to protect the innocent.
This is the city. Los Angeles, California. I work here. I'm a cop. It was Thursday, December 10th. It was cold in Los Angeles. We were working the day watch out of robbery division. My partner's Frank Smith. The boss is Captain Didion. My name's Friday. I had to report to the police academy firing range at noon. It was 7:55 a.m. when I checked into room 27A. Robbery.
Stand still. What's the beef? I'll shake him, Joe.
Put him down. Get him up.
38. 45 automatic. Put your hands down. You keep yours up. All right. Hands in back of you. Let me have your cuffs, too.
You gonna put cuffs on me?
And put your hands down. All right, where are your pals?
What pals?
Cliff Small and George Shum. We know you're running with them.
If you know that, then you know where they are.
How old are you?
18.
What's your name?
Julius Carver.
Everything okay?
Yeah, Tony. Any sign of the other two?
Didn't see him. Car's still staked out. Nobody's come near it.
Okay, you and Jack want to take these two downtown. Frank and I will wait for Shum and Small.
Right. See you down there.
Here, take their guns, will you? Here, Tony. Right. Let us have your cuffs, will you? Thanks.
Okay, let's go.
For those of you that were watching closely, yes, indeed, the young man in the mustache was Leonard Nimoy, who went on to play Mr. Spock in Star Trek. Apparently, he went on to play Mr. Spock after he got out of prison for doing the crime he did in Dragnet. But let's watch the second video and see what happens.
Better.
He really cares about you. You know, that's something you just can't help. There's no way to stop that.
What are you still doing here? Are you a glutton for punishment or what?
I said I was going to stay here until I knew that you were okay, and that's what I'm going to do.
That could be a while. Ah, what do you want?
Detective Taggart is here to read you your rights. I'm here to watch.
She likes to watch. You have the right to remain silent. Anything you say can and will be used against you in the court of law. You have the right to an attorney, and for that attorney to be present during questioning. Do you understand this? And these rights as they've been read to you?
Yes.
Do you wish to have an attorney present?
Enough. I've been through this dance, okay? I know it by heart. I'm not in the mood to do it again.
Yeah, well, we're gonna make it real interesting this time. We're gonna send you to prison.
You'll notice in the Dragnet episode that Jack Webb started interrogating the suspects immediately after they'd been arrested. He didn't read them their rights or anything. At the time that was filmed in 1954, it was perfectly constitutional to do exactly what Jack Webb had done. It wasn't until 1966 that the Supreme Court changed the rules for custodial interrogations. For hundreds of years, the standard of English and American law were that confessions were lawful unless they were the result of actual coercion. But that all changed in the case of Miranda versus Arizona, and now the police have to read you your Miranda rights that you saw in the second drama. This is where the idea of original intent meets up with due process. The requirements under the Due Process Clause for custodial interrogation should not change over time. It should mean the same thing in 1868, 1954, 1966, 2011. It shouldn't matter. If the law needs to change, we do it by passing new laws, and that's done by the legislature, not by the courts finding new meanings for constitutional terms. But with the Miranda rule, the Supreme Court changed the meaning of due process insofar as it comes to the rules about interrogating a person in custody. Here's what Miranda requires. Before the police can question a suspect that's in custody, they must inform him of his right to remain silent and his right to a lawyer. If the police forget to read a suspect his rights, does that mean he gets off scot-free and he doesn't have to face any of the criminal charges? No, it doesn't mean that at all. All it means is that anything that the suspect says to the police can't be used against him. And usually that's not fatal to the case. Sometimes it is, however. If the police, in a murder case for example, don't give the suspect his rights and he blurts out a confession and tells them where the body is buried, well, they can't use his confession and they can't use the body to convict him. And he may get away with it because they failed to read his rights to him in a timely fashion. So sometimes the failure to read the suspect his rights can indeed result in him getting off scot-free, but it's not automatic. There's another way to look at Miranda and other changes that the Supreme Court made to the standards of due process during the years of the Warren Court. By now, you know that I believe that courts should not make up new law. They should follow the law as it's written. There's a limited exception to this principle. Courts should be allowed to make up rules for the conduct of trials. This would include the rules of evidence. This is part of the common law power of courts, which is carried over from English practice to American practice. And still today, all courts, including the federal courts, have the ability to make procedural rules for the courts, including the rules of evidence. But here's a big caveat. If the legislature disagrees with any court rule, it can change it through ordinary legislation. It is very, very difficult for Congress or the state legislatures to override court decisions if they're based on constitutional rulings, because it takes 2/3 of both houses of Congress and 3/4 of the several states to change the Constitution. But if all we're talking about is a rule of evidence, then a simple majority of the state legislature in Virginia, for example, can change any rule of evidence adopted by the Supreme Court of that state. And a simple majority of Congress can change any rule of evidence adopted by the U.S. Supreme Court. Now, there's some good policy arguments in favor of the Miranda rule. People should be warned before they give up their rights. Those same good policy arguments would lead to the conclusion that the police should also be required to read you your Fourth Amendment rights before they go into your house without your consent. But the Supreme Court has not required warnings about your Fourth Amendment rights because they're selective and not very logical about which rights you're to be told about in advance. We often get distracted in evaluating Supreme Court cases about whether or not we like the substance of a particular rule. I happen to like the substance of the Miranda rule. If I were a member of Congress and were voting on whether or not federal crimes should be prosecuted only with giving people a warning of their right to remain silent, I'd vote for that rule as a member of Congress. But I have trouble with that being imposed by the Supreme Court without the original intent of the Constitution to back them up. This is a policy question, and we elect legislators to make policy decisions, no matter if it's the Due Process Clause, the General Welfare Clause, or the Commerce Clause. The Constitution should have a fixed and knowable meaning if we're going to follow the rule of law. Judges should never be allowed to make the law, even if we like the law that the judge is making in that particular case.